Chief Judge Clement, may it please the court, I am Carl Brown of the Nashville Bar, and I represent Mid-America Apartments, doing business as the venue in Cool Springs. If I could have the permission of the court, and absent any objection from the appellee.
Well, how much time do you want to reserve?
Oh, I'm sorry, Your Honor. 3 minutes.
3 minutes, certainly. Please proceed.
I've brought a photograph that was in the record of the subject pedestrian bridge.
Does counsel have any opposition to us seeing the photograph?
As long as it's in the record.
Very good. All right, if you would show it to him before you present it to us.
Okay, thank you, Your Honor. It is it's at the Technical Record, Volume 3, page 408. It's Exhibit A to the plaintiff's response to the defendant's motion for summary judgment that was in the technical record. It's also attached to Dr. Dethridge's report, which was trial exhibit number 13.
And Dr. Dethridge is not a medical doctor, but a PhD.
Yes, sir.
Mm-hmm.
I have no reason to.
Very good. All right, thank you. And this is a photograph of the walkway or the path where the slip and fall occurred.
Yes.
Okay. All right. I think we've all seen it anyway since it's in the record, but you're certainly welcome to refer to it.
Thank you, Your Honor. By way of background, the venue at Cool Springs is a very nice apartment complex in Cool Springs. Mr. Trentham had lived there for close to 2 years prior to the incident, the fall, that forms the basis of this action. As I will explain further, the trial court's order in this case, when reading all the premises liability law in this state from this court and the Tennessee Supreme Court, creates an impossibly high bar for premises owners and provides no guidance whatsoever on how a diligent proprietor like the venue might avoid liability in the future. There was simply no evidence of constructive notice in this case to sustain liability under existing and extensive case precedent regarding a proprietor's duty. In this case, the superior knowledge of the proprietor, as established through a constructive notice, analysis, and duty, are the main points that are at issue in this appeal. As this court is aware from the trial court's order, this is a rainy day slip and fall case involving a fall on this pedestrian bridge in a high traffic area of the venue where residents cross this bridge frequently every day to get to the amenities on the property, the community center, the mailboxes, including Mr. Trentham himself for 2 years prior to his fall, including admittedly in the rain because it was the shortest route from his apartment to the fitness center. The bridge had existed for 8 years. It had been designed to shed water. The trial court failed to hold Mr. Trentham to his burden of establishing the existence of something other than rain that caused his fall. In this case, he alleged the existence of organic growth, algae, or slime, but failed to provide any independent, objective, empirical evidence whatsoever. More critically, even
his testimony was quite specific and graphic, and the trial court found him to be a credible witness.
Yes, Your Honor.
So we have that. He said it was slimy. He said it was slick. And so how do we ignore that?
Your Honor, I'm not asking you to ignore his testimony. I'm asking that the court compare it to the evidence in the other rainy day slip and fall cases, and especially Gordon. And the opinion of the court in Gordon was delivered by Judge McClarty, and it cited Barron versus Stevenson, and it cited Nee versus Big Creek Partners. All of those cases had more evidence, including the case cited by the trial court, Williams versus Lynx Corp. In Williams versus Lynx Corp, the same kind of algae or natural growth existed, but in that case, the plaintiff presented affidavits of his golfing partners that also said, yes, we saw it, it was there. And there was also a prior lawsuit against that golf course. Now, most importantly, however, even if...
One of the things that somewhat puzzles me about this case is that there was an employee of your company, your facility, that aided him in getting up, and that testimony was not presented. He did not present any testimony at trial.
That witness did not appear at trial, Your Honor, but his written report was relied upon by Mr. Trentham's expert, Dr. Dethridge, in his analysis of the bridge. But no, that witness didn't testify other than the fact that there was a written statement that he provided about the incident that then Dr. Dethridge relied on in forming his opinion.
Okay.
But even assuming, if you do assume that there was some sort of a condition that he slipped on, even if you assume that, he still has the burden under Gordon and Friedenstab and the other cases, Barron, to prove constructive notice, because under Gordon, superior knowledge is the true basis of the proprietor's liability. The proprietor has to have superior knowledge. And in Gordon, the plaintiff was a pizza delivery person, and she had delivered pizza to the buy-low, as she had many times before, going over a ramp, realized part of the order was missing, returned to get the rest of the order, during which time it started to rain. She returned to the buy-low after it had started to rain and then slipped on the same ramp less than an hour or an hour after she had been over the ramp previously. She produced pictures of glistening oil spots on the ramp and said, "This caused my fall." The court said, "No, that's still not enough because you just went back and forth over the same ramp." The same thing happened here. In addition to the hundreds of times Mr. Trentham had crossed this bridge previously, he had crossed the bridge an hour, the trial court observed, before he fell. So how does the proprietor now conduct itself if it only takes an hour or less for knowledge, for the constructive knowledge component and superior knowledge to be established?
I don't believe there's any claim that the entire bridge was covered with algae. It was just a section that he happened to walk on as he was returning to his apartment.
And from that standpoint, Your Honor, what if somebody had spilled something in the hour between when he went across and when he came back? It's the same as the other non-rainy day slip and fall cases involving substances.
But then again, what if someone spilt something, but he described it as being a growth like algae, which is different from something being spilled?
And wasn't there expert testimony that this is something that could happen, that occurs with this type of structure?
And let me address the expert's testimony about that, because that expert, Dr. Dethridge, testified about not the fact that there was actually algae or growth on this bridge. He didn't testify to that. He testified from Knoxville that he looked at photographs that he admitted in cross-examination were too dark to tell, but he surmised, based on just experience, common experience, if you don't take care of wood, it can form algae. Now, his specific testimony was it would take algae or fungus at least 3 months under extremely wet, shady conditions to grow. 3 months under perfect conditions. This is a quote from trial. Under predominantly dry and intermittent wet conditions, it could take more than a year for algae to develop on the surface of this pedestrian bridge.
Then that brings us to your client's own testimony, Ms. Phillips and a couple of others, none of whom could say that this was ever pressure washed in the last 2 or 3 years, even though their protocol required such.
And that brings me back to, if the more diligent a proprietor is, the higher the standard of diligence is required. Because without any proof of any substance on this bridge, no proof, none like the other cases, now the burden has shifted to the proprietor. Now you have to prove nothing was there. You have to prove a negative. And then you have to prove, because we're diligent, we need to be more diligent. Pressure wash more. Pressure wash all the time, even though the experts said 3 months.
No, not all the time. The question was, has it been pressure washed in the last 6 months? Not to my knowledge. Has it been pressure washed in the last year? Not to my knowledge. Are you aware of it ever being pressure washed while you were an employee? No.
And then how did we?
Every one of your employees said something consistent with that.
And I agree, Your Honor, that's predominantly the testimony. But they did testify that pressure washing did occur on the property, and they had a pressure washer.
Yeah.
But how did we get to the pressure washing issue to begin with? First, the plaintiff has to prove superior knowledge or constructive notice of something to trigger that duty. There was no duty in this case.
Well, Judge McClarty just said it's known in the industry that algae will grow, and thus a property owner has a duty to occasionally inspect and pressure wash.
And the court recognized in its order the inspection procedures of the property. And if I could just if I could just go to the testimony that the court actually acknowledged, the court acknowledged Elizabeth Phillips and Billy England's testimony that they inspected on a regular basis, and that after the fall, Elizabeth Phillips testified, excuse me, after the fall, they looked at the bridge, they put up that caution tape, because that was their first notice of any problem. They acted immediately. They saw no algae. 4 days later, this picture and notice from Mr. Trentham was provided to the property, and he said, resurface it. So they did. First notice, they acted immediately. And in the course of acting immediately, the testimony was, we go through here and cross this bridge regularly. The trial court acknowledged these are touch points. The employees cross it all the time. It may not be called an inspection, but they cross it regularly in the course of every day. The one photograph Mr. Dethridge brought to trial was one he took on his first visit the day before trial, and it showed sun shining right on the pedestrian bridge. There was sun. It was sloped. It had slats. It was designed, he admitted, to shed water. It did not have the conditions that he himself said were required to form algae within the time it would take to form and not have someone else fall. All these people are going to their mailboxes. If algae is forming on this bridge over a 3-month period under perfect conditions, dark, standing water, someone else is going to fall or report it, including Mr. Trentham, who in his testimony said, I especially go over that bridge when it's pouring rain because it's the closest route from my apartment to the fitness center. So there's no constructive knowledge in this case. There was no superior knowledge proven. If this case is allowed to stand, premises owners are going to have to prove a negative. They're going to have to come forward when somebody falls and say, this is what we did. This is why we are not liable. That makes them an insurer.
What about the notion that maybe you didn't have constructive knowledge because you didn't follow your own internal policies?
And that's the heightened standard that I said earlier.
Why is that a heightened standard?
No one testified at trial, including Dr. Dethridge, about a standard of care generally. The only testimony
there was an internal policy that was obviously considered.
And the case law we cited in our brief sets forth that you cannot be held to a higher standard because of internal policies. And it's public policy reasons for that.
And there was testimony that people had not pressure washed it for years, perhaps.
Well, not for years. They do it at least annually.
Okay.
But there was testimony that they did pressure wash it at one time on a somewhat of an annual basis.
Yes, Your Honor. And when they painted and...
But later on, they were lax in doing so.
But they were crossing the bridge at all times, and there was no reason. That's the point. If there's nothing on the bridge, how many times do you have to pressure wash it in order to satisfy the duty when someone falls? It's an impossible burden and standard, and it makes them an insurer of their patron's safety. And every case in Tennessee starts with the admonition. The proprietor cannot be held to a standard that they ensure the patron's safety. This was a high-traffic bridge. It wasn't in an isolated area.
Right. All right. We'll hear from you further on rebuttal. Thank you, Mr. Braun. Mr. Malone.
Good morning. Morning, Your Honors. Charles Malone of the Nashville Bar on behalf of Mr. Trentham. In short, the trial court judgment should be affirmed. There are no valid basis for their appeal, and they have resorted to straw man arguments and mischaracterization of the record, claiming that the trial court found them to be an insurer, imposed strict liability, eliminated the element of duty, and that is absolutely not true. A review of the trial court's memorandum opinion after a full trial shows that the trial court made fully supported findings of fact based on the preponderance of the evidence, where there was conflicts of witness testimony, engaged in appropriate credibility determinations, and then took those facts and applied them to black letter Tennessee law from the Supreme Court and this court on premises liability. I'm going to address and focus on what Mr. Brown talked about just now. And let's start with the existence of the unreasonably dangerous condition, the algae on the bridge. Mr. Trentham had evidence in support, including his own testimony in detail, the fact that he told MAA the day after the fall of the slime algae on the bridge. He presented Dr. Hal Dethridge, the professional engineer, head of University of Tennessee's construction department. With all due respect to Mr. Brown, Dr. Dethridge testified unequivocally that it is more likely than not that there was algae growing on that bridge because it had not been pressure washed, and that was pure science. He also testified...
Did Dr. Dethridge describe the conditions of this bridge and trees and shading and what have you?
Dr. Dethridge described, well, first, yes, he described that there's trees around it, it has periods of sunlight, it has periods of shade, it is exposed to the elements, just like any bridge. There was nothing unique about the exposure to the elements. I mean, the bridge wasn't in the desert, it wasn't in a swamp. It was just in a area with trees, but the bridge did have sunlight.
Now,
and
there are photographs of the bridge, but to my knowledge, I haven't seen any photographs of the algae.
The algae, there are no photographs of the algae because MAA changed the surface of the bridge after the fall. Dr. Dethridge, the first thing they did was they put strips that had a grit on them so you would not slip. Dr. Dethridge, there are photographs of those strips would not adhere to the wood because of the algae. So then they had to take those strips up and they put a textured paint on them. And so there were no photographs.
You said there's photographs of the strips not attaching to the wood because of the algae. Then why haven't I seen photographs of algae?
Well, they're in the photographs of the bridge show the strips. I mean, it's an algae.
But
it's not a green, thick algae.
Do they show the algae or
No, Dr.
any
Dethridge's testimony, Your Honor, is that this microbial growth is not something that you walk up and is visible to see. It's something that develops over time. It's not a thick moss-like or green-like algae.
But your case is premised on the fact that it had developed over time.
Yes.
So why can't we see it?
Because it is not something that is visible, according to the experts.
Then if it's not visible, how could the apartment complex see it?
Because of their testimony that they know that they have to clean this bridge. And we asked them, what do you do to safeguard the tenants from this bridge, in an interrogatory response that is in the record? They injected the standard of care. They said, we comply with the standard of care. So I took Ms. Phillips, the verifier of the interrogatories, the executive vice president of MAA's deposition, and I said, you comply with the standard of care. What does the standard of care require to keep this bridge from developing this condition? We have to pressure wash it once a year minimum, and more often if it gets worse. And then the next question, when was the last time you pressure washed it? And it's a series of questions, and it was a series of years since they had pressure washed it. So
this is water over the bridge, so to speak. But was there any attempt to get this employee who witnessed the fall or who was there at the time he fell to come in and testify as a witness as to what he observed?
There was not a formal attempt. I wouldn't say that there's an attempt in the record. I will say that Mr. Trentham presented his testimony, Dr. Deathridge's testimony. Their expert admitted that algae would grow on this, and their own MAA's testimony that algae would grow, and we made a conscious decision that we had satisfied our burden. MAA had identified in its interrogatory response 2 employees who had knowledge of the condition of that bridge, Mr. Townsend and Amanda Suvering. I may say the name wrong. She was the manager. They elected not to call them to trial. And Mr. Brown...
For missing witness, that you make a motion that the court charge itself on missing witness?
I did not, Your
See
Honor.
that in the record.
I did not, Your Honor. We believed that we'd satisfied the burden, that it was more likely than not, and trial court agreed with us. Mr. Brown did say up here that Ms. Phillips, and I'm sure it was a mistake, innocent, that Ms. Phillips had inspected the bridge following the fall. That is false. That is not in the record. In fact, in the record, it is clearly stated by Ms. Phillips that she never inspected this bridge. So MAA affirmatively elected not to call a witness to dispute Mr. Trentham's testimony, Dr. Deathridge's testimony, or even its own employees' testimony that they knew this bridge would develop this condition if they didn't pressure wash it. And that's what this comes down to, is their appeal on this issue of unreasonably dangerous condition. They're asking you to just decide that all of this evidence is not credible. And the great irony of all these cases that Mr. Brown cited is these plaintiffs will show up in a slip and fall case with no expert and no testimony and nothing but a photograph. And the defendants will come in and say, we get summary judgment. That's not enough. And now the tables are turned, and you've got MAA up here with nothing but a photograph and saying, you've got to relieve us of liability. And it just is not sufficient to overturn the trial court's verdict. As far as constructive notice, in Blair versus West Town Mall and Parker versus Holiday Hospitality, constructive notice essentially boils down to, should the defendant have been aware of this condition? Not were they actually aware, but should they have? Do they have information or knowledge of a fact imputed by law because the defendant could have discovered with proper diligence, and the situation was cast upon the defendant the duty to do so? That condition can be caused by a method of operation, by a third party, or by natural forces. In this case, MAA has admitted constructive notice. They say we have the standard of care internal policy. They tried to walk it back. It doesn't matter. The standard of care, our internal policy, we know this bridge will develop this condition if we don't pressure wash it annually. And they didn't pressure wash it in 2018. They didn't pressure wash it in 2017 or 2016 or even 2015. So 4 years. So they knew that their failure to do that would cause this condition. And if you analogize it to the Blair case, the West Town Mall case, in that case, the plaintiff's theory was that buses and commercial vehicles would stop at a specific point outside the mall and leak fluid. And that was constructive notice to the defendant that they needed to be aware of that situation and rectify it, because that is where the plaintiff had slipped. The Supreme Court reversed summary judgment for the defendant and said they hadn't overcome their burden. Now, in Blair, if you took Blair and added the element in this case, if the mall had then showed up at trial and said, yes, we knew if we didn't come out there and clean that spot where those buses stopped, it was going to get slick. And by the way, we haven't done it in years. That is the element of constructive notice. That is an admission of constructive notice. They know they need to do something or somebody's going to get hurt, and they don't do it. And their argument that this is the first time it's happened is not availing. The Tennessee law does not require an exact or even a prior injury. You don't get a mulligan. You don't get one injury free as a landlord. You have to exercise due care. And if you have constructive notice of a dangerous condition, and in this case, I submit and we submit that the trial court was correct in its findings and applied the correct findings of fact to the black letter law. I will say, Your Honor, there is a second grounds that we had of negligence per se in this case. It's an alternative grounds. It's an academic debate based on the trial court's findings, but if this court has any concerns about the slimy algae substance, negligence per se is an independent grounds on which this liability
And
verdict should be affirmed.
That was based upon the code's requirement if this bridge is considered an access, an egress and ingress to a building, and the trial court concluded it was not.
With all due respect, I think there was two grounds. The experts agreed. There was a dispute between the experts as to the reason the code applied. The code required a slip-resistant surface and code-compliant handrails. No dispute by any party. The bridge did not have that. Dr. Deathridge said the code required it because it was a means of egress and because it was an accessible route. Their expert, Mr. Rice, had a dispute on the two reasons it was required and said there was only one, it was an accessible route. But they both agreed the code applied to the bridge. The bridge was required to have the specific surface that it did not have, and the bridge was required to have handrails that it did not have. The only dispute was Mr. Rice, MAA's experts, showed up at trial and said, well, I've changed my opinion. My opinion now is that the city of Franklin blessed the violations of these codes or deviations from these codes because it issued a certificate of occupancy. The trial judge, the trial court rejected that opinion, did not allow him to offer it because it wasn't disclosed. I would submit that opinion is also an improper expert opinion. That's not an expert opinion. That would be a fact that they would need to go get from the city of Franklin. And the code itself says the issuance of certificate of occupancy is not a approval or blessing of a violation of the code. So the trial court, in his opinion, if I read it correctly, determined that negligence per se was not applicable because he did not believe the code to be mandatory, according to the case cited in the opinion. In Tennessee law, there are two types of codes, the prescriptive versus the, get the right word, Your Honor, suggestive. Prescriptive code is mandatory, a suggestive code, an aspirational code. Well, if you look at these code sections on the handrails and the flooring, the slip-resistant floor, the code reads in terms of the word shall. The egress, the bridge shall have a slip-resistant floor. The bridge shall have code-compliant handrails. With all due respect to the trial court, the word shall is a proscriptive, mandatory requirement. It is not an aspirational requirement, a suggestion, or an encouragement. So we do submit that the trial court erred in not finding a second grounds of liability, which was negligence per se. But again, that's an academic debate because the trial court's finding of liability based on the algae and microbial growth was correct. And there's no need to have two grounds, but in the event this court has some concerns, the negligence per se is a valid ground also. Your Honor, I'd just like to close, although Mr. Brown didn't talk about it. The damages award in this case was fully supported by the evidence. It was fully supported by the law. The court engaged in the exact analysis mandated by Overstreet versus Shoney's, put down a case, seminal case on lost earning capacity in this put down by this court. We've got an issue where the plaintiffs put forth evidence on Mr. Trentham's lost earning capacity and had an expert testify it to be $550,000 to $560,000. Dr. Hutchison, professor at University of Tennessee, Chattanooga, testified it was $1.4 million. The court had a credibility battle. Both experts had enough information to make the assessment of lost earning capacity, past and future. The defendants never objected to any of that testimony or evidence, and the court was left with a credibility determination between Mr. Trentham's evidence and MAA's evidence and made an appropriate decision that should not be reversed on damages as well as liability. So unless the court has any questions for me, I don't have anything further.
Hearing none, thank you, Mr. Malone. Mr. Braun, you have some time for rebuttal.
Thank you. First of all, and most importantly, I want to take issue with one of the things, very respectfully, that Mr. Malone said. He said that the employees at the venue said, "We know this bridge will develop algae, and that's why we pressure wash." Nowhere in the record does anyone with the venue say, "We know this bridge will develop algae, and that's why we're pressure washing." Nowhere. That, the trial court in its order said specifically, "I find that the venue had no actual notice of the hazard and that it did not create the hazard." That was a specific finding of the trial court. And no witness testified that, "Oh, we know it develops algae, therefore we pressure wash." The pressure washing was part of a comprehensive property management plan. They did it for many more reasons than just this bridge. They were maintaining a beautiful property, one that Mr. Trentham himself testified that was one of the most beautiful he'd seen in a long time. This is not a shabby property. They are exercising extreme diligence, and because of that, they are now being penalized, and the burden is being shifted to them to come forward with witnesses, to come forward with other evidence that there was nothing, to prove a negative. Where was the algae on Mr. Trentham's shoes? Where was the algae on Mr. Trentham's clothes? Where was the algae that he took a picture of, either while he was on the bridge waiting for the EMTs or later? Where was the person he asked to take a picture of this algae? Nowhere. Your Honor's correct. There's not a picture of the algae. Dr. Dethridge himself testified that the pictures he looked at were too dark to be able to tell. And the conditions were not at all like Dr. Dethridge described would be necessary for algae to grow. There simply was no constructive or superior knowledge in this case. As a matter of fact, Dr. Dethridge relied on Cameron Townsend's testimony and said that, and Cameron Townsend, since we're talking about it, said in his statement, "I specifically looked and saw no algae." Dr. Dethridge said, "Oh, I'm disregarding that. He's a layperson. He wouldn't be able to recognize it if he saw it." But in addition to that, these strips and all this other talk of subsequent remedial measures should not be admissible. But since it's such a topic of conversation, yes, on first notice, tried the strips, heeded Mr. Trentham's advice to change the surface, did it all immediately. This is 4 days after the fall. That photograph right there, 4 days after the fall with the caution tape. On first notice, they jumped on it. They did what a diligent proprietor should do. And if I could just briefly say, in Blair, the court in Blair said the evidence wasn't enough potentially at trial. The court said the evidence in this case, in Blair, we express no opinion as to whether the defendant in this case had constructive notice of the dangerous condition alleged by the plaintiff. Sufficient facts are not present in this record. The facts that Mr. Malone recited about the oil spots were not sufficient. Judge Goddard said, if the evidence remains substantially the same as in the present record, Westtown Mall might well be entitled to a directed verdict. So Blair, decided during the Hannon versus Alltel years, does not support Mr. Trentham's case as he has stated. It supports the venue. And my time's out, but if you have any questions.
All right, thank you, Mr. Braun and Mr. Malone, for your arguments. We will take your case under advisement. All right, call the next case, please.
State of Tennessee, ex rel. Herbert H. Slater, III, Attorney General and Reporter,